Okay, this is cause numbers 22-39100 and 22-39101. Are you Latisha Tibo? And Ms. Tibo is currently on probation for failure to comply with sex offender registration in each of these cases. I looked this up. I think there may be, and Ms. Simon's here, this update report says 2 10-year adjudicated probations, but it was a 2-year term.
It was 2 over 5.
2 over
2
5.
TDC over 5, correct?
Right.
Excuse me, sorry, that was an error.
Okay, just making sure. And so Ms. Tibo was previously here, entered pleas of true to counts 2 and 4 in the motion to revoke probation. And I've received the updated pre-sentence report. Have you all received that updated report?
State has to.
Any additions or corrections to that other than the one that I already made?
Nothing from the state.
Nothing but
And there was no agreement. Is there any evidence with regard to the other counts, Mr. Hoffpower?
Any new failure to register.
No. I don't know. She pled true to counts 2 and 4, so there's
Correct.
obviously some other counts. Do you have any witnesses or evidence
No,
with
no.
regard to those other counts?
We're going to abandon those counts. We'll just proceed on 2 and 4.
Okay.
Other than I call my probation officer, but I like her opinion.
Okay, so I guess there was an arrest in
It's in Florida.
Palatka, Florida. Okay. Hold on a second. Let me-
Putnam County.
Okay, so count 1. Why don't you have any evidence with regard to count 1 if your probation officer's here?
We can call. I'm sorry. Apologize, Your Honor.
Ma'am, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may proceed.
Would please take the name for the record, please.
Sarah Simon.
I'm assuming are you the probation officer assigned to Ms. Tibo?
I am.
Okay, and how long have you been first supervision officer?
Year and a half.
Okay, and throughout the time that you've been a probation officer, has you complied with the terms of her condition? Either one of the cases?
Speak up, please. I'm sorry.
Okay, no, she has not.
She's not.
Yeah, okay, in what instances has she not complied?
Ms. Tibo has had consistent reporting habits. She was not paid towards her processed fees. And she's introducing it to
Was she allowed, first of all, was she allowed to do her probation in Texas to venture out of the state and be in Florida?
She did not.
Okay, she wasn't allowed?
She was not allowed.
Is she allowed through her reporting as a sex offender to move or go to another state without no probation? I mean, is she allowed to leave the state?
No, without.
She pled true to that.
Okay.
Count 1 is that she has not reported since January 27th of 2025.
Is that true, ma'am? Is she
That is true.
intermittently or she is fully, she's been called absconded?
She is absconded.
Okay, since that day?
Yes. Or 90 days after that time in January, she became absconded.
She's been absconded. Okay, and since she reported since the time when she was arrested?
She has not reported
Have you spoken to her at the jail?
at the hearing.
All right, did she give a reason for why she didn't report?
She did not.
At this time, pass it on.
Okay, I also would like to know, Ms. Simon, were you able to confirm in any way the arrest? Obviously, she's going to say she didn't do it, and that's okay, but if she was actually just, whether an arrest happened in
Yes,
Florida?
I did obtain an arrest report from Florida.
PC, okay. All right, but do you have a problem cause? Do you have a full offense?
The full
all the same incident?
Yes.
And what date did that occur, according to the law?
June 29th, 2025.
And were both those committed?
Objection as far as committed, Your Honor. I don't object to her listing evidence as far as an arrest. but
An
As far
arrest.
as the actual commission, it would violate a right to front cross.
Did the allegation occur?
Yeah, the arrest.
The arrest occurred while she was on probation?
Kelly, this just did something again.
Case.
Correct.
And those haven't been resolved here today?
Not now.
Absolutely, Your Honor.
Yes.
She initially failed to report in January, is that right, of 2025?
That was the last face-to-face contact I had.
January 2025. Then arrest, June 29th of 2025.
Yes.
So February, March, April, May, June, 5 failures to report. And she went into absconder status March of 2025,
Maybe April,
April,
like 90 days after.
90. So April 2025, she became an absconder. 2 months after that, she was arrested in Florida, is that right?
Right.
So you were aware she was in Florida, which state, when were you made aware that she was in custody in
I
Florida?
received a phone call from somebody that let me know that she was arrested and in jail in Florida. And then that's when I obtained this arrest report.
So when did there was an MTRP entered into NCIC, I guess, after April? Was there an MTRP and that's why Florida advised you there was an active warrant for her then?
There was an active warrant for the MTR. She was arrested for the.
Right, and that warrant popped up in June in Florida.
Correct.
So from June 29th to today, she's been in custody, is that right? So
I
she
didn't try to
couldn't
open
report
anything,
it
it just started doing stuff
to
on its
probation
own.
department. She's in custody from June 29th to today because she's locked up.
I don't care.
That's not her fault that she didn't report because she's in custody, correct?
She was in custody.
So she can't report.
Correct.
As far as supervising her, she has reported, you say inconsistently, but that means she has reported some, correct?
Correct.
During the times that she has reported, have you been able to interact with her appropriately? She maintained proper demeanor?
Today's story takes us deep inside the probation violations of Latisha Tibo. What started as a simple failure to report spirals into arrests across state lines, shocking probation records, and even new criminal charges. But here's the twist. This isn't her first time in front of the judge. So buckle up, because this case reveals just how far someone will go to dodge responsibility.
That type of thing?
That she was consistently late. I had to reschedule her several different times to get her to the office.
Have you had any other difficulties with her as far as just maybe perhaps being late with scheduling, as far as your actual interactions? Did she maintain appropriate demeanor, acted appropriately with you?
Yes.
Would you object to continuing to supervise her?
I would.
Why is that?
My personal opinion, I don't think this too close sees her probation as a priority. She has been on probation, I think, since 2022 and has made no progress in regards to her fees. She did some community service, and that's about it.
When you say progress, how do you measure progress on probation?
Satisfying her court order conditions.
And how has she fallen short other than the reporting and fees and community service?
If she committed
So
an
is this correct in the, hold on a second, hold on. Is in the updated report, it states that since she was granted supervision, has reported 6 times for scheduled office visits. Is that a correct number? Okay. 6 times since 2022.
I have another question, Your Honor.
Let's let Mr. Kimler finish.
If she were to be extended, which the court has the power to do, I mean, you would continue to supervise her, right? Or would you have a problem with supervising her consultants?
I would work with her.
See any indication of the need for some type of mental health referral or anything of that nature? I mean, I understand she's only reported 6 times, as the judge indicated. You see kind of programs or other things that probation could do for her, maybe perhaps to get her on the right track?
I think the only other option would be the cognitive genetics.
Pass witness.
Your Honor, is this the first time that we've been here on these two cases for a motion to revoke?
No.
There was another time back in 2024 in which we had a hearing similar to this, not me, especially as the attorney, but she was brought in on a motion to revoke, and her probation was amended, and she was given 30 days in JCC, and she was continued, and she was added to the mental health case.
Her probation officer is outright saying she's been late, missed appointments, and failed to treat probation as a priority. That's a big deal. In probation, consistency is key, and 6 office visits in nearly 3 years is shockingly low. Think about it. Would any of us get away with ignoring deadlines like this at work or school? And yet here she is, standing before a judge, trying to explain why her freedom should continue.
The high medium case, she didn't report enough to be transferred over to the high medium case.
So this is not even the first time that we've been here on this, on similar allegations. That was a year in 2024, we did the same deal. Is that correct?
I might follow up on that. I believe in the previous HURP, she had a motion, again, a motion to revoke. She had federal charges, is that right?
Correct.
The NTRP was filed after she received the federal charges,
I believe so, yes.
and she was housed in the cell unit. Were you supervising her then?
I was not.
Do you know if the detainer was placed on her for that NTRP while she was in federal custody?
I did not.
Did she actually do federal time while she was on probation for this case?
That is why the NTOB was dismissed.
So she received, I think, about a year sentence in federal court for misprision of felony. Is that consistent with what you know?
1 year federal probation.
Prison, she was locked up, right?
She got probation.
She had 1 year federal probation.
Probation, okay, for misprision? Or you don't know? What the offense was?
I thought it was a possession.
Okay. Anyway, she received a year of federal probation, so she was not revoked and was allowed to serve the probation concurrently.
Correct.
So during the period that she was on federal probation for that year, do you know if she was reporting to a federal probation officer? Was any issues with the federal probation you're aware of?
According to Ms. Tibo, she successfully completed her federal probation.
And that was at the same time that she was on probation with Jefferson County. Is that right?
Correct.
Was she reporting to you during that time period as well? What was her reporting record in Jefferson County during that period? I guess it was probably back in 2024.
Well, she's reported 6 whole times since, so obviously it wasn't great even when it was then.
Right. But she was being supervised at least during that period federally and was able to successfully complete that probation, correct? Does that indicate to you that perhaps she could successfully complete Jefferson County probation if she's sufficiently motivated?
She has the ability to, but whether or not she has the motivation or the want to do so.
Pass one, Your Honor.
All right, any other questions?
No, Your Honor.
All right, thank you, Ms. Simon. Any other witnesses?
No, Your Honor.
I would defer to Ms. Tibo, Your Honor, if she wanted to address the court. I think she has written to the court, and that letter's incorporated in the PSI.
I received it and read it. Anything else?
No, I mean, I did fail to report it. Sometimes I was hard with scheduling, but a lot of it had to do with my mother being sick, and I brought my mother sick to her office with me multiple times because I wasn't able to just stay with where she was at. I brought her when I could. I mean, she's passed now, but at that time frame
But,
after,
I mean, we're talking about since 2022.
I was in
Or
a
20
federal facility for a year and a day.
Okay. All right, so here's the thing. I'm not even sure where this agreement came from and why I accepted it in the first place, because giving somebody the minimum of 2 on a probation, so I have really nothing to do hardly on this. But Ms. Tibo, I mean, you've been given every opportunity over the last 4 or 5 years to do everything you're supposed to on this probation, and you've refused to do that.
This isn't her first rodeo. She faced a similar hearing back in 2024, and even then, the court showed mercy with probation instead of prison. But mercy doesn't erase responsibility. Repeat violations show a pattern, not an accident. What do you think? Should a judge keep giving chances to someone who consistently breaks the rules, or is it time to finally draw the line?
You flat out refused, and everybody, we all have different issues that go along with parents and family members and things that go wrong. And instead of, it looks like, I think one of the things that concerns me the most is that you called June 2nd asking why the police went to your home. June 2nd you called. And so your probation officer said there's a warrant because of your violations on June 2nd. Then you went to Florida and got arrested for 2 new offenses without registering, without obviously telling anybody where you are and the type of probation you're on, the offense that you're on probation for. That's probably the number one thing that you should do. So fleeing the state when you know that there is a warrant for your arrest gives me no reason to leave you on probation. Unfortunately, I think for me and for the community, the most I can do is 2 years, and so that's what I'm going to do. I'm going to find, based on the evidence today, that counts 1 and 3 are true. So I'm going to find you entered your pleas of true to 2 and 4 freely and voluntarily, find all 4 counts true, find sufficient evidence to revoke your probation, and cause number 2239100, revoke your probation, sentence you to a term of 2 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 2239101, also find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. You need to sign that, please. I'm handing you the trial court certification that shows there was no agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that, and he'll give you a copy of that as soon as y'all get it signed. Thank you for being here. Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I was saying the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this. But I think that she regrets what happened, and hopefully not engaged in the type of conduct that caused this to occur.
And here's the judge laying it bare. Years of opportunities wasted, chances thrown away, and violations stacking up. Think about that. Probation is already the lighter sentence, yet she ignored its simplest rules. Then fleeing to Florida while knowing there was a warrant? That's not just negligence, that's willful defiance. At this point, the judge's frustration feels justified, and the tension in this room couldn't be higher.
It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So obviously, if the court repeats 5, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address as well. Is that right? What do you have to say for yourself?
I apologize for the situation that went on, and I wish that anybody whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full rating.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report where you were put in the
And just when you thought it couldn't escalate, we shift to another case tied to Smith, and this one involves violence against an officer. What began as shoplifting spiraled into physical confrontation. Now the prosecution pushes for 6 to 8 years. This moment highlights the dramatic shift from petty thefts to dangerous behavior. Question for you: when does small crimes stop being small when someone repeatedly ignores the law?
parish jail, and then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies, that ended up with you going to prison. 5 years was, it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, you know, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery. Sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition.
So here's where it all lands. Probation revoked, prison sentences confirmed, and Smith's history catching up with her once and for all. What started as a shoplifting spree turned into felony convictions, officer assault, and years behind bars. These hearings show us one truth: the court can only give so many chances before accountability takes over. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler. I did.
You went on the robbery, and that we actually entered the plea on the assault.
Sorry, 25 DCCR 0979
Right, assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I'll just say on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated.
Okay.
All right. And we have to have that discovery certification today because the
Yeah.
case is going to get to close
Not
down.
again, you never gave it to me.
Well, I mean, when she first pled.
So do I?
You didn't give
You
it.
to give me a
Do I get the credit for me being in here on this?
Yes, all the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit.
Okay.
Okay?
Thank you.
Good luck to you.